we are going to open the show today with a discussion on the update of the death row situation of Mr. Sunday Jackson. Now we have the copy of the dissenting opinion of Justice Ellen Morenikeji Ogunwumiju, who has affirmed that indeed Mr. Sunday Jackson acted in self-defense. And she has actually gone ahead to also support the plea for clemency in that situation. To join us in that discussion, we have all the way from Washington, D.C., the Nigerian lawyer who brought this case to limelight, Mr. Emmanuel Ogebe. Emmanuel, good to see you again on Inside Sources.
Always a pleasure to be with you, Laulu.
All right. And here in the studio, we have with me Abuja-based Nigerian lawyer, Mr. Ibrahim Wali. Ibrahim, thank you for coming to Inside Sources.
Thank you, Mr. Laulu.
All right. Now, so let's start with you, Emmanuel. So one of the things that I find exciting about the opinion of Justice Ogunwumiju is that not only did she affirm that Mr. Sunday Jackson acted in self-defense in a very strongly worded ruling, she also supported the clemency plea to Governor Fintiri. What's your take on that, Emmanuel?
This was clearly a vindication, not only for Sunday Jackson, but for any right-thinking member of the public, because the issue of self-defense is intrinsic to every single human being on the planet. So all of us had a visceral reaction to a judgment that seemed to indicate that we did not have any such rights. Well, let me start with something that Justice Ogunwumiju said. In the circumstances of this case, I do not think the appellant was in a position to determine and analyze which part of the body of the deceased to stab. He had a right to want to get away from his attacker and to ensure he was no longer pursued. As stated earlier, at that point of reaction, would a reasonable man who had already been stabbed twice by a trespasser on his land think twice about stabbing the assailant anywhere available? I think not. I do not agree that the mere fact of stabbing the deceased 3 times in the heat of the moment instead of once constitutes malice aforethought. And here is the very important part. Under our legal system, if a man is in danger of serious bodily harm, he may use such force as he believes is necessary to prevent and resist the attack. And if in using such force he kills his assailant, he is not guilty of any crime, even if the killing was intentional. So Justice Ogunwumiju has preserved our fundamental right to self-defense as enshrined in the Constitution. And we should all be thrilled about that. The second thing she did, which was pivotal, like you pointed out, is that she said that Jackson is a proper candidate for clemency. So the job has been done. As far as I'm concerned, this is signed, sealed, and delivered. The governor of Adamawa State needs nothing further than to issue clemency or a pardon for Jackson at this point.
Okay. Thank you for those opening comments. Let's take it to Mr. Wali. So now we've read the dissenting opinion of Justice Ellen Morenikeji Ogunwumiju, who actually is also the head of the 5-man Supreme Court panel. What's your take?
Well, the dissenting opinion of Her Lordship Justice Ellen Morenikeji Ogunwumiju, I would say, was a stellar jurisprudential rendition that was hinged on not just the agreed facts of the case or not just the regurgitated facts of the case, but she went on further to scrutinize the records of proceedings, including and especially the testimony of Sunday Jackson in court, where she put it side by side with the confessional statement. Remember, in the major decision, there was a position where they held and said that the confessional statement and his witness statement in witness testimony in court, there were glaring inconsistencies. Yeah. So she looked at it and said
they chose to believe the confessional statement rather than...
Yes, but she said that the testimony was merely an expansion of the confessional statement and there was no material inconsistency, especially with regards to his plea of self-defense. She held that, from his confessional statement to his witness statement, to his testimony in court, he is consistent in, his position that he acted in self-defense. She said that both lower courts agreed that indeed he was not the aggressor because these are the elements of self-defense, especially under Section 33, subsection 2 of the Constitution. The exceptions as to when a person can lose his life, in defense of your life and in defense of your property. Right. So she said that both courts agreed that he wasn't the aggressor, because the cows were pushed and chased into his farm before he was even, chased himself. And she agreed that the force that he used was necessary because obviously, part of the decision that he just read was that what would the reasonable man do at that point? She even held, in fact, that the courts below, both courts below, agreed that he had stabbings. Although the courts tried to say that there was no medical report like we had discussed earlier, but she said that the trial court especially, held that there was stabbing in at the back of his head and on on his leg. So she's saying that if in the first instance he tried to escape and he was injured, in his leg and at the back of his head, then it is a reasonable thing to do, to want to, counter or to curtail any further danger. And that's why she said he wasn't in any position, he didn't have the privilege to decide where to stab or where not to stab. And she made a distinction between, intention to kill and premeditation. She said that in a case of self-defense, it doesn't matter if you intended to kill the person, as long as it is necessary, as long as the danger is imminent, and as long as you're not the aggressor. And she also, expanded. So she said you might have the intention to kill her, yes, which would make it murder or culpable homicide punishable with death. But was there premeditation? Did you plan to kill him? Did you want to kill him? She said these two people were strangers. He was on his farm when he drove his cows into his farm. So there was no premeditation. He didn't even know him before. They didn't have any prior issue. But obviously at that point in time, due to the attack, and she emphasized the fact that, it wasn't even his knife. He had to wrestle the knife from him. Yes, so he used his own knife against him. That he was not, and there is no evidence, according to the court as well, led by the prosecution to show that no, he didn't act in self-defense. He had the chance and opportunity to actually flee from the scene, before he took the action that he took. But she really went into the facts. I think this is the first time that the court actually attempted to really scrutinize the facts themselves as against just, regurgitation of what the law is, So even when she mentioned what, the law around self-defense is, she went ahead to assess each of the factors alongside the Sonjay Jackson's case. And she came to the conclusion that, he was in the right to actually defend himself. Everything proves that he was in the right to defend himself. But she made a crucial statement that I found very interesting. She said, if you are going to convict a man for a serious offense of this nature by his confessional statement alone, then it is only befitting that you take the entire statement in its entirety, because parts of the statement is why he was convicted, mostly, the main evidence on offer. But even there in the confessional statement, we've mentioned this as well, the plea of self-defense was raised, and the prosecution did not, put forth any evidence to counter it. So, she said that to her mind, a man cannot be in his own house and you'd come and attack him in that manner. You'd expect, any sort of, for him to reasonably and, wisely, try to douse the situation without, engaging in that manner. And she held that, that's the defense of a plea of self-defense is exculpatory. It means if you succeed, then you're acquitted completely. So she said that, yes, in our decision, she finds him discharged and acquitted. However, because she's in the minority, she has proposed and advised the governor to offer him clemency. But I'm not surprised by, my Lord's diligence and, the appreciation of the fact and the usage of reasonable mind, because she said it as well. What would a reasonable man do in that position? And I think that that is a very, very key test in all of our, judicial matters. Okay, what would a reasonable man do so that the judgment is going to be befitting, the situation and the context itself. But yes, Justin Helen has been one of the justices that has tried to push, that legal puritanism or that, jurisprudential approach and rendition to decisions. I remember in Aviomo versus COP, she pushed for, the mandatory, making, the clauses for taking confessional statements, in recording and ensuring that, there's a lawyer in present, and all those procedural, provisions of the ACJA that have not really come to light. She expanded it, and she said that law enforcement agencies henceforth must, abide by the law. She did the same with criminal defamation at the time. I cited the case at the time where she said that it ought to be relegated and stuff like that. So it's not surprising that she took this reasonable man route. And if you put the judgment side by side, you would appreciate, at least even on the surface, the fact that she went deeper with regards to the facts. Yeah. And I think that is the best way to appreciate a legal position. Yes.
Okay, thank you so much. Clearly, Her Lordship Justice Ellen Morenikeji Ogunwumiju has done a great good to our sense of natural justice as a people. And I think, Emmanuel, you did make that point, because, it was sending, people of goodwill and people of regular common sense. It was becoming really, really incredible to have to understand how we have lower courts, high courts, that is, and appeal court, and then a majority decision, to say that this man was guilty of murder. So we must thank Justice Ogunwumiju, as a layman, I will say that. But final question I wanted to ask you, Emmanuel, is, so reading the opinion of Justice Ogunwumiju and how she was able to separate the issues, just like Ibrahim has said, do you think that that Mr. Sunday Jackson's counsel at the High Court would have done better in terms of, what ended up to be his confessional statement, which was what all the justices at the Court of Appeal and the 4 justices at the Supreme Court stuck by to say that, look, he said that he killed him intentionally, and as you recall, that confessional statement was at what point withdrawn and then restored. So I wanted to ask you, Emmanuel, because you came into this case pretty earlier than most people. Do you think, the role and the experience of Jackson's lawyer at the High Court, do you think, it could have been better handled? You are also a lawyer.
Yeah, so here's the issue. And I agree that Her Lordship has to be commended. And Nigerians need to be encouraged that there are voices of reason in the court still who will speak out for the common man, even against the majority. But here's the issue. There were those who blamed the defense counsel at the High Court, a legal aid counsel who I met and who I found to be an intelligent chap because they said he withdrew his opposition to the confessional statement. But if you read Her Lordship's judgment, she was very clear that, in fact, the so-called confessional statement was consistent with his testimony in court, and that it merely expanded on it. And so even her own interpretation of those facts justified the actions of the defense counsel and says that he did not make an error. So this judgment is very beautiful and is to be commended. But there's another part of this judgment I want to quickly mention, which should encourage all of us. And this is the fact that she actually validated stand your ground as our constitutional right. She said, I believe the misapprehension of the lower courts in finding the appellant guilty because he did not run away after he gained the upper hand is from the unwarranted and unreasonable interpretation of the need for the person attacked to disengage no matter the circumstances. As stated earlier in this instance, the appellant had disengaged once and was pursued. Did he not have the right to stand his ground against further attack on his own farm? I'm of the view that he reserved the right to stand his ground on his own land, pursuant to Section 32, subsection 2A of the 1999 Constitution. Then she concludes, I'm of the view that the defense of self-defense avails the appellant and his response was not excessive. It is my view that the judgment of the two lower courts should be set aside as a miscarriage of justice.
I felt, some of these sentiments, and I look at the fact myself, which was why the last edition, I decided to make this part of my take to say that we must advance clemency, which is what I now want to ask Mr. Wali, in addition to whatever you want to make your last word. How much time, what are the rules that guide the governor in the discharge of his prerogative of mercy in this matter? Now, we have the father of the deceased, supporting the clemency. And now we have the most senior Supreme Court justice who had this case making a very strong appeal for clemency. Just like Emmanuel said, I think it's almost a done deal, but we don't want to preempt the governor. But talk to us, Ibrahim, as we wrap up on the, is there a timeline? What's the framing of the discharge of Governor Fintiri's prerogative of mercy in this matter?
With regard to the clemency, frankly, it is very, direct and clear in the Constitution that it is at the discretion and mercy of the governor. Just like when it comes to federal offenses, it is at the discretion and mercy of the president. But obviously, it goes on to say that the governor shall have a prerogative of mercy team, who shall per quarter review cases that are due for
a quarter.
Yes, well, from time to time is what it says. It's just my imputation.
Right. Yeah.
Yes, to review all cases, and to see if they, deserve clemency. So, like I said earlier, maybe if they had proactively set up all of this, or maybe they have it or not, but how our appointments and how our institutions and committees are run, maybe if they, had an active prerogative of mercy committee on ground, they would be the ones to even take it up and advise the governor, in support of the clemency. But I believe that the judgment, of her lordship is very clear as to, the need for clemency to be extended and offered. But like I said earlier, it's only about conditions. There's no timeline. It can be this year, it can be next year, or any time. It can be this governor or the next governor. It doesn't have to be 23, just in case. But like I said, miscarriage of justice, perversion of justice, good conduct, good character, and then public policy are all conditions and grounds, and the decision of the, executive in that regard is not even questionable or even subjected to the, approval and ratification of the National Assembly or State Houses of Assembly. So it is really left for the governor, and I really advise the governor to actually, have his senior officers in the state, have a second look at the issues, read all the judgments from the trial court to the Court of Appeal and, to the Supreme Court. If they even want to go further and invite the respective police officers or the judge to give a statement or anything, so that, they can actually consider the clemency.
Thank you. Thank you so much, Mr. Ibrahim Wali, and thank you so much, Emmanuel Ogebe. I think that we just want to call not just the governor, Governor Fintiri, but the Attorney General in Adamawa State to please, commence the procedure for the consideration of this matter, because we do know it is in the public domain that Mr. Jackson has been in detention, in custody, for over 10 years already. We even understand that he didn't even know that his second daughter has been born, and John only met her through a photo. So we do have compelling humanitarian grants for the Attorney General to speedily initiate this procedure that we hopefully hand on the table of Governor Fintiri, and we are hoping very soon that we will hear the good news that Mr. Sunday Jackson is free. Thank you so much.
I can quickly update that they already have his clemency application, and it's already been reviewed. And I want to say that the chairman of the Human Rights Commission, Tony Ojukwu-San, added his voice to the plea for clemency this week.
Okay. So
we're getting more and more support globally for Jackson's clemency.
Excellent. Thank you for that, Had. So, Governor Fintiri, please do this nation a whole lot of good by acting in favor of this request. Thank you so much again, Mr. Emmanuel Ogebe and Mr. Ibrahim Wali.
Thank you, Mr. Lawal.
Inside Sources will be right back.